Presiding over this year's competition is the Honorable Ketanji Brown Jackson of the United States Supreme Court, the Honorable Joan Larson of the United States Court of Appeals for the Sixth Circuit, and the Honorable Patty Saris of the District Court for Massachusetts. Our sincere thanks to our esteemed panelists for their participation tonight. We'd also like to thank our case writers, Joseph Pasamato and William Bergstrom, both Harvard Law School class of 2017. Tonight's case turns on the scope of the Second Amendment and who may claim rights and the government's ability to restrict those rights, consistent with the history of the Second Amendment. The two questions presented are, one, whether a non-citizen unlawfully present in the United States who has substantial ties to the country is part of the people with Second Amendment rights. Two, whether the government can disarm non-citizens unlawfully present in the United States, but with substantial ties to the community consistent with the history of the Second Amendment. A more detailed case description can be found in your programs. I'll now announce the teams. Representing the petitioner, the Honorable Justice Sandra Day O'Connor Memorial Team, we have, first, oralist Arvind Ashok, oralist Emily Malpass, Edward Ned Bless, Andrew Hayes, Richard Nierbos, and Daniel Wasserman. Representing the respondent, we have the Honorable Constance Baker Motley Memorial Team. We have Vishali Chaudhry, oralist, Sophia Quende, oralist, Andrew Kogut, Elle Bulabach, Alexandra Mack Taylor, and Alex Fredman. Before we begin, a gentle reminder that no laptops, cell phone, or other electronic devices may be used during the competition. Please take this opportunity to confirm that you have silenced any electronic devices you might have with you. Please don't take photos during the competition, and please refrain from leaving the courtroom during arguments. Finally, following the announcements of awards, there will be a reception at the HLS Pub in Wasserstein Hall. Thank you very much and enjoy the competition.
All rise. The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
We will hear argument now in the case of Daniel Wells versus John Doe. Counsel, are you ready to proceed?
Yes, Your Honor.
You may begin.
Madam Chief Justice, and may it please the court. My name is Arvind Ashok, and along with my co-counsel, Emily Malpass, I represent the Attorney General of the United States. I will argue that John Doe is not part of the people protected by the Second Amendment, and my co-counsel will argue that Section 922 G5A, the long-standing federal statute that disarms him, is consistent with the Second Amendment. We'd like to reserve 3 minutes for rebuttal. History, precedent, and common sense show that Mr. Doe is not part of the people. The Constitution does not grant unlawfully present non-citizens the right to bear arms. History at the founding and this court's precedents confirm that the original meaning of the term of art, the people, in the Second Amendment referred to citizens only. Considering an unlawful non-citizen's connections to this country has no basis in history at the founding and would leave courts in the difficult position of parsing nebulous connections without any clear standards. Even if this court disagrees with that and includes some non-citizens with sufficient connections to this country in the people, unlawful non-citizens, like Mr. Doe, cannot have sufficient connections.
Counsel, you started with history, precedent, and common sense, but your brief also talks about the text. Can we talk about the text of the Second Amendment, which uses the words the people and not citizens, and yet somehow you want us to interpret it to mean citizens.
That's correct, Your Honor. We believe the framers used the terms the people and citizens synonymously. We believe they used the term the people when they were discussing rights that were oppositional to the government, and they used the word citizens to signify an equality between citizens and each other. We get this idea from 1787 Connecticut Chief Justice Jesse Root, who wrote about the people being used to connote an oppositional relationship. And we think that's evidenced by the fact that you see the people constantly throughout the Bill of Rights, but you don't see the word citizens. You see the word people in the Declaration of Independence. And then when you see the word citizens elsewhere in the original Constitution, it's to signify this equality. So for example, in the Privileges and Immunities Clause, the citizens of one state have equal privileges and immunities to the citizens.
Has this court ever interpreted the people in that way? I mean, there are cases in which the Supreme Court has interpreted the people, and I don't recall that analysis factoring in.
No, Your Honor, we don't believe this court has ever provided a definitive definition of the term the people. I will note that in Heller and this court's subsequent Second Amendment jurisprudence, the rights holders in the Second Amendment are always referred to as citizens. But if you're alluding to the Verdugo-Urquidez case, where the court did attempt a provisional definition of the people, we don't believe that definition is binding in any regard, and that's for a couple of reasons. First, when the Verdugo-Urquidez court defined the people as those with sufficient connections to the country, it did so only in contradistinction to the attempted assertion of Fourth Amendment rights by a Mexican citizen in Mexico. It never defined what sufficient connections would mean with regards to a non-citizen.
But counsel, didn't Heller cite the entire definition from Verdugo-Urquidez? So I'm not quite sure why you think that Verdugo-Urquidez would be limited just to a Fourth Amendment context. We used it in the Second Amendment.
Heller did cite Verdugo-Urquidez, Your Honor, but if we look to the context of Heller, we see that it cited that language from Verdugo-Urquidez for a narrow purpose. Heller is trying to prove that when the Second Amendment says the term the people, it's referring to an individual right, not just one that can be exercised in the context of a militia. So it pulls this evidence from the Fourth Amendment context and says that the people is a term of art that signifies an individual right and all these other rights that mention the term the people. However, we don't believe that Heller lifted this language about the people referring to those with sufficient connections. In fact, as I was just mentioning to Justice Jackson, when Heller refers to the rights holders of the Second Amendment, it's consistent about the fact that those rights holders are citizens, and subsequent Second Amendment precedent, McDonald, Bruin, Rahimi, all continue this reference to citizens.
One of the things I was worried is if you did it, you defined the people the way you just described it, what does that do to the other amendments in the Constitution? In other words, the people shows up in the First Amendment, Second Amendment, Fourth Amendment, Ninth Amendment, et cetera, and there's a clear distinction between that and citizens, as you say, in the main body of the Constitution. So if we defined it as narrowly as citizens, how does that affect the rest of the constitutional analysis?
So it's true, Your Honor, that all of those other amendments mention the term the people. However, we don't believe a ruling in this Second Amendment case would bind future considerations of the First and Fourth Amendment. I would note here that Mr. Doe hasn't provided any evidence or any holdings from this court that clearly establish that non-citizens have these First or Fourth Amendment rights. But if this court is concerned about the scope of those rights, it can always deal with them in a future case. Because I think when this court has considered the First and Fourth Amendment particularly, it's looked less to original meaning than it has in the Second Amendment. Consistently starting with Heller defining the phrase the right to bear arms, this court has looked to original meaning to define the Second Amendment. But if you look to United States versus Jones, for example, in the Fourth Amendment, which looked to original meaning to define what a search was, it didn't immediately jettison its non-originalist line of cases starting with cats. And the other reason that we don't think the First or Fourth Amendment would be affected is that if this court believes that Verdugo-Urquidez gave non-citizens some assumption that they might be able to assert these Fourth Amendment rights, then the court could rely on stare decisis in a future Fourth Amendment case and hold that they have those rights. However, here in the second...
Wouldn't that be odd? You want us to read the word that's the people to mean different things in different places. Can you give me an example of a place in the Constitution where we have read the same word to mean different things?
Well, Your Honor, Heller gives the example of state in two different places meaning different things, but we're not necessarily asking for inconsistent rulings across different amendments here. We're just saying that in this Second Amendment context, the question that's before this court is to look at the original meaning of the term of art, the people, and we certainly think there are important considerations to be, important things to be considered with respect to the First and Fourth Amendments, but that's a question for a future case. And we think,
so what is the original meaning? Help me to understand your evidence regarding the original meaning of the people.
So we give you founding era evidence that suggests that the framers understood the term of art, the people, to be synonymous with citizens. And the piece of evidence that I would particularly point you to here is the 1787 North Carolina High Court case, Bayard versus Singleton. The North Carolina High Court interpreted a right in the North Carolina state constitution of, quote, the people to receive a jury trial with respect to their property transactions. And the North Carolina High Court said that citizens, but not aliens, could assert this right. And we think this is the best piece of evidence that either side has provided here because it's speaking to the use of the people as a term of art rather than the colloquial definitions that Mr. Doe provides on pages 17 and 18 of his brief. His founding era dictionaries don't align with the rule that he provides in the rest of his brief. Those dictionaries point to the outlandish definition that that people refers to something like all non-citizens within the border of the United States. But then if you look at his rule, it says that the people refers to all those with sufficient connections. And that's something that we don't.
So I'm just wondering, when you why not use, why are you so resistant to the way the term has been defined in Heller and Verdugo and all the rest of those cases? Essentially, you want us to narrowly define it as citizens, but you have a fallback. I think the other side called it a retreat, but whatever, a fallback to possibly people who are just illegally here. Why are you pushing so hard for the outer boundaries?
Well, Your Honor, we believe that starting with Heller, this court has always looked to original meaning to define terms in the Second Amendment specifically, and we think this court should do so again here. And because we think the best read of founding era history and the precedent in Heller suggests that the people are citizens, we think that's the line this court should hold. However, you're correct to identify that we have this alternate argument that if the court accepts the definition in Verdugo or Quidez that the people refers to those with sufficient connections, it should still decide that the only connection that is sufficient is a formal engagement with the naturalization or immigration process.
Why?
Well, for a couple of reasons, Your Honor. First, because we provide some founding era history that suggests that to the extent non-citizens were discretionarily granted access to rights of citizens by states near the time of the founding, those states did so based on the non-citizens' engagement with the federal naturalization or immigration process at the time. We give you a couple of state laws on page 8 of our reply brief from New Jersey and South Carolina that reference the federal naturalization or immigration process, and they said if the non-citizen takes an oath and commits to staying in the country for a couple of years, they can get access to a right of citizens.
And what does it mean to have some engagement with the naturalization or immigration system? I mean, is it sufficient if you came into the United States lawfully on a student visa, and then you overstayed that visa? Is that sufficient? I mean, you came into the country lawfully.
Your Honor, I think we would say that receiving the student visa would warrant getting a sufficient connection, and perhaps there would be complications.
Even though you overstay for 10 years. You're Mr. Chadha.
I think that overstay would probably cut off whatever formal engagement that you had, but receiving a student visa and being here legally on that student visa would qualify as a sufficient connection under our definition. And we think
wouldn't that be the closest to what we've held before? In other words, if you're here on a green card, or you're on a student visa, or all the lawful ways you can be in this country, wouldn't that be part of the political community in the way that we've just defined it before?
Well, Your Honor, when this court has used the term political community, it used it in Heller, and in prior cases where it's used that term, it's used it to refer only and exclusively to citizens. We give you a couple of cases, Foley versus Connolly and Cabell versus Chavez-Salido, where the court upholds statutes limiting the ability to be a police officer to citizens only, and then it uses the term political community in that context. And so we wouldn't say that the words political community has the this more expansive definition in this court's jurisprudence. But regardless, we think that it's perfectly possible for this court to resolve this case by deciding that only people with lawful status have the sufficient connections necessary to meet the language.
But why is that? I mean, going back to my colleague's question about engagement, I understand an engagement that occurs when you are granted the ability to be here, but don't we also have a situation in which a person like Mr. Doe, who has been submitting to the law, doing everything he's supposed to do in the context of his being here, why isn't that engagement? I mean, he hasn't committed a crime, for example, while he was here other than the illegal entry. So why wouldn't that be a situation in which he should be receiving the same kind of consideration of engaging?
Well, it's certainly true, Your Honor, that Mr. Doe might have subjectively engaged with the country in some sense, but we think that this court needs an administrable rule by which to define sufficient connections. When lower courts have attempted to define what a sufficient connection is, they've yielded wildly inconsistent results, and so we believe conditioning sufficient connections on some form of formal engagement with the immigration process is the only way to resolve that inconsistency. And just to give you an example here, if you look at Mr. Doe's brief, he points to 3 different lower court cases that are supposed to define what a sufficient connection is, but all 3 lower court cases are incompatible with each other and point to a different definition. He gives you one.
Isn't that just the nature of a standard? I mean, we have different fact scenarios, and we have a standard, for example, that you have to have engagement, sufficient connections, and different courts are going to look at it differently. I think that's just a function of the way the law works, right?
Perhaps, Your Honor, but I think that in this particular case, you would get, if you look at the results that people have come to, they haven't developed these they haven't developed an applicable standard that is consistently applied across lower courts. And I also think that, with regards to this threshold question, we don't think there's any analog for a standard specifically with regard to considering an individual person's connections. We think there are standards with regards to other fact patterns that develop on the ground, but not with regards to, for example, Mr. Doe mentions his subjective connections, his community ties. We think all of those things would be very difficult for a court to verify. It's very difficult to imagine, for example, a court deposing members of Mr. Doe's softball team to decide whether he actually had the connections that he asserts.
Counsel, I see your light is on, so I want to take your last 30 seconds if I can. You say the people is equated with citizens, and that's in contradistinction to persons, correct? So you do think that aliens could have some rights when they're attached to being persons, right? But I'm wondering about how this is going to work with respect to state laws. So the Second Amendment in McDonald, we incorporated through the Due Process Clause of the 14th Amendment, and that is attached to persons. Persons have 14th Amendment rights. So is the standard you're arguing for going to be inconsistent between the federal government and the states?
No, Your Honor. I believe that when this court has incorporated amendments, it's generally kept the scope of those amendments consistent.
Well, it has, but textually, how are we going to ground that if we've said that the 14th Amendment Due Process Clause, which attaches to persons, is the right home for incorporation?
Well, I believe McDonald itself provides us some clue as to how this inquiry would work, because McDonald says that one of the reasons it incorporates the Second Amendment in the first place is that it says that it's an essential right because once the 14th Amendment passed, newly freed Black people were guaranteed the rights of citizens to bear arms, and it cites evidence that suggests that because it was a right of citizens, that's why the right was essential. And so I certainly think that just due to the nature of the right itself, it would inherit to citizens particularly. And I would also point out that Justice Thomas's concurrence incorporates it through the Privileges and Immunities Clause. And I think, may I briefly finish the answer, Your Honor?
Yes.
I think that to the extent that the Privileges and Immunities Clause is the fifth vote there, I think that the citizens line would be the one this court takes. For the foregoing reasons, Your Honor, we respectfully request that this court reverse.
Thank you. Whenever you're ready, counsel.
May it please the court. My name is Emily Malpass, and I will be speaking for 16 minutes about the government's ability to disarm unlawful non-citizens, including John Doe. Section 922 G5A is consistent with the Second Amendment because it shares a why and a how with relevantly similar founding-era laws. Two separate principles from our historical tradition of firearm regulations support this conclusion. First, Congress has broad power to disarm individuals who break the law. Consistent with this long-standing tradition, founding-era legislatures disarmed individuals for crimes ranging from assault to fraud to nonviolent peace-breaking. Today, Section 922 G5A disarms an analogous class of lawbreakers. Second, the government may disarm individuals who have not manifested allegiance to the United States. Just as historical regulations disarmed groups ranging from loyalists to Confederates until they manifested allegiance via a formal legislative process. Today, Section 922 G5A operates in the same way for the same reasons. John Doe's as-applied challenge would hollow out the guarantees of Section 922, the federal law that does more to protect Americans from gun violence than any other. This court should reverse.
So is it your position that any form of lawbreaking is sufficient? It doesn't have to be a felony. The lower courts, for example, have struggled with 922G. I read a lot of lower court opinions. And the lower courts have struggled with 922G with respect to felon disarmament, but you seem to be taking a position that's much broader than that. So misdemeanors could also be disenfranchised.
We think it encompasses...
Or not disenfranchised.
We think it encompasses both individuals who commit felonies and misdemeanors. Here, under Rahimi, we simply fall back to the time of the founding, and we look at two regulatory traditions we see there. First, we look to the state ratifying convention proposals in Massachusetts, New Hampshire, and the highly influential Pennsylvania dissent of the minority, which substantiate disarmament for crimes committed, real danger of public injury, and times when individuals weren't peaceable. We see that founding-era legislatures acted on this understanding to disarm individuals, including nonviolent peacebreakers in Massachusetts in 1692 and 1795, in New Hampshire in 1708, as well as laws from Virginia and North Carolina from 1786 and 68, respectively.
It's amazing you remember all those dates. So good for you. I was just curious about the historical debate here because the brief. Your brief sort of says we should look back to the British. We took away guns from loyalists and Catholics and all these groups of people. And yet what the opposing brief says, no, the Second Amendment was meant to be different from what happened in England because it was, as you say, the people against authority. We should be looking to the separate meaning that was provided in our Constitution. And we often look to England, a common law tradition, and then sometimes we're looking away. And I'd like to know your thoughts on what you think the best historical analysis would be.
Well, let me sort that into buckets. First, we think that insofar as the founders were moving away from a pre-ratification tradition, they were specifically rejecting the disarmaments that British generals had done to American patriots at the dawn of the Revolutionary War. We cite in our brief the example of General Gage, who required all residents of the Massachusetts Bay Colony to deposit their arms at Faneuil Hall. We think it was these disarmaments that inspired the Second Amendment, but not the other ones. And we note that the founders, the very individuals who ratified the Second Amendment, disarmed loyalists consistent with the amendment. We note that many of the disarmaments went into effect during the Revolutionary War and then stayed in practice until, for instance, we cite a North Carolina session law still in effect in 1804, and many were still in effect during Jay's Treaty, which was signed in 1794.
I guess I don't understand. So can you help us to figure out, first of all, what is the right era to be looking to for determining the historical analog?
Well, we think this court has provided us with helpful guidance on this. The court says that we should adopt traditions that come from our common law origins, but that were not made obsolete or were not applied during the founding era. So if we see traditions that come from, for instance, we cite the 1328 Statute of Northampton, but then we later see this incorporated into our founding tradition and the fact that many states passed laws that were almost word perfect that 1328 statute. So those traditions are relevant, but traditions that have gone by the wayside would not be.
What do you do about your friends on the other side say it's not all lawbreakers, it's violent lawbreakers, that really the historical tradition is not as broad as you indicate in your brief.
We think this is an obviously under-inclusive principle. We specifically, again, cite that 1692 Massachusetts Act, which disarms individuals who are, quote, disturbers or breakers of the peace, as well as the 1708 New Hampshire law, which was substantively identical. The Massachusetts Bay Colony, after ratification, reincorporated that same law in 1795 to again disarm peacebreakers. The earliest liquidation...
Doesn't the idea of being a peacebreaker, disturbing the peace, suggest some sort of violence, some disruption to the community? I mean, there are laws today, and I assume that you would say that state laws count. I mean, is that correct? So if you violated a state law, it doesn't have to be a federal law, you could still be disarmed. So in New Jersey, it is a felony to open a bottle of ketchup in a supermarket and put it back on the shelf. So that person loses their Second Amendment rights?
We again think that the founding era evidence speaks to a broad scope of authority to disarm, but there might be some laws that we could start distinguishing on. We could try to find some kind of limit. This court in Rahimi alludes to the fact that many of these laws are tied to a special danger of firearm misuse, and we think that principle could help cabin the rule here today. However, for what it's worth...
Would it capture Mr. Doe?
Absolutely, Your Honor. And we provide you with two reasons why. We think first that unlawful non-citizens as a class are specifically unlikely to comply with registration requirements because they're often unwilling to give full and honest identifying information to law enforcement. And second, we think that unlawful non-citizens are often subject to deportation and arrest, and arming these individuals, as the Eighth Circuit said, precisely at the moment authorities seek them, might lead to cycles of violence that would affect both law enforcement and non-citizens.
Since the government has to prove beyond a reasonable doubt that the person knew they were violating the law, you couldn't have that flexible, as you said, well, maybe ketchup wouldn't be enough. So essentially, you're urging us, as I understand it, for some sort of categorical, no people who are illegally here. That's what you're looking for.
I think we could frame this as a question with the Rahimi inquiry, Your Honor, where Rahimi requires us to provide a justification. And here we think we provided a single justification from the time of the founding, which is that the founders believed they could disarm people because they broke the law. But now we're starting to ask about the whys that lurk behind the why. So for reasons why the founders thought it was necessary to enact this principle. However, Rahimi simultaneously commands us to faithfully respect the balance struck by the founders. And this puts us in a bind, because once we start second-guessing the justification the founders had, we seem like we're second-guessing the balance struck by the founding and performing some kind of historical means-end scrutiny, where we ask if the regulatory tradition we're pulling from is adequately supported.
But of course, isn't the sort of threshold question whether this really is the balance struck by the founders? I mean, the concern, I think, is that when you're looking back at the historical record, you find certain cases, the other side finds certain cases. So how do we know whether the historical tradition was all lawbreakers or just violent lawbreakers?
I see no evidence that it's just violent lawbreakers. Again, we cite numerous founding-era laws, as well as the state ratifying convention proposals, which we think speak most directly to the scope of the Second Amendment right and to the scope of the government's regulatory authority.
Do you concede that it's your burden to persuade us that this is the tradition?
We think we carry a burden of persuasion in this case, but we also think that Heller in dicta states that laws like this one are presumptively lawful, which means Mr. Doe needs to take you slightly more than halfway. He needs to get you to 50% and a feather to show that this law isn't constitutional. But if he doesn't...
Is that how you read Heller? I mean, I've been struggling with how the burdens work in a situation like this, where it seems like Bruin says the burden is on you to at once, assuming that Mr. Doe is covered by the Second Amendment, which was the first part of this argument, the burden is on you then to show that there's a historical analog. So I'm not quite sure I even understand how Heller is sort of preserving some kind of a burden for Mr. Doe in this situation.
We think that Bruin is dealing with a different type of law. Heller enumerates a set of categories of laws that have this presumption of lawfulness, and it specifically lists 922G1 and 922G4. We think it would make little sense if that presumption didn't roll over the period into 922G5. But both Rahimi and Bruin dealt with categories of laws that don't enjoy this presumption of constitutionality from Heller's dicta. And so we think that the burden is different today. For what it's worth, we think it's just a presumption of lawfulness. So if you walk away from this oral argument and you feel like both sides have made good points, the history is messy and difficult to parse, then we think that Mr. Doe hasn't carried his burden of getting you over that halfway mark.
But I guess but Heller was before Bruin, so you still think that the presumption of lawfulness remains, even though we now have a pretty clear test from Bruin that doesn't reference any particular categories and suggests, with its burden shifting, that it's your burden to help us determine the historical analog.
We absolutely think Heller's dicta carries on. I'll note that Justice Kavanaugh separately wrote in Bruin specifically to reiterate that the felon in possession ban in 922G1 is presumptively lawful. He was joined by the Chief there. The Chief reaffirmed this again in dicta in Rahimi, and Justice Kavanaugh again wrote separately to underscore that point.
Do you think the domestic violence one, though, is distinguishable because it was more recently enacted? And I know Justice Kavanaugh was talking about that the other one has been enforced, since the 1960s. So do you think it matters what year the 922G was amended to add a particular prohibition?
Precisely, Your Honor. So we don't think the presumption of lawfulness attaches to 922G8, which was specifically considered in Rahimi. And so the references to the presumptively lawful nature of the felon in possession ban were just in dicta. But again, we would distinguish here the Violence Against Women Act was enacted in 1994, and we're dealing with the 1968 text that Heller specifically says is presumptively lawful.
Wasn't it open to us in Rahimi, though, to enact basically the rule that you're asking for, which is law-abiding? That law-abiding language comes from Heller. We didn't seize upon that in Rahimi. Instead, in Rahimi, we said that an individual must pose a clear threat of physical violence to another. The threatening individual may be disarmed. So it was perfectly open to us to draw the bright line you want us to draw then, and we didn't do it. So I'm just a little puzzled by that.
We actually think it might have been deliberately closed in that case. I'll note that this office specifically ceded at oral argument that law-abidingness had anything to do with the rule at issue in Rahimi. There, the government pushed for a rule that's based in civic virtue and again steeped in founding-era evidence. But this office specifically did not say that the underlying lawlessness of Mr. Rahimi's action should have led to his disarmament. But we now endorse that principle today because we think that under the Rahimi test, it becomes much easier to generalize from a suite of founding-era evidence exactly this kind of principle. And we think, again, Rahimi has given us valuable advice about construing that principle at the correct level of generality. So we've gone as narrow as we can go, and we've refrained from inquiring into the reasons why the founders might have struck the balance that they did. Instead, we simply think, looking at the founding-era evidence, there are laws that disarm individuals who are nonviolent misdemeanants. Mr. Doe is a nonviolent misdemeanant, and the government would like to disarm him today.
How do you respond to respondents' suggestion that as a historical matter, every male was required to be armed as part of their militia duties, whether they had been previously convicted of criminal behavior or not? So lawful behavior was not an impediment to arming men in the historical times.
I'm not sure we find much evidence to substantiate that proposition, other than, I believe, a secondary source they cite for that. Instead, we think that if an individual committed a crime at the time of the founding, it was taken very seriously. We'll note that many felonies were warranted, were worthy of instant death and warranted extended prison sentences. So I cannot imagine that the founders would have thought that an individual who was disarmed for any reason was subsequently required to take up arms on behalf of the United States. One of the biggest traditions we see from the founding is that the founders treated criminality as a crime of violence against the state often, and that all but ensured that an individual wasn't going to be taking up arms to defend the security of a free state, which is what the Second Amendment commands.
Much of what you say is persuasive, but doesn't it argue for the narrower reading rather than all citizens, just the people who've committed a crime?
Could you clarify that for me? I'm not sure.
In other words, if you go broadly with what your fellow counsel urged, all citizens, all non-citizens, even if they were legally here, can, be captured under this provision, wouldn't and you're focusing on committing a crime, which here would be unlawful entry, wouldn't that argue for the narrowest possible reading of this in order to support historical tradition that they've actually committed a crime rather than someone who is just here because they got a green card?
Well, so green card holders aren't subject to 922 G5A's bar. Instead, under 922 G5B, they're presumptively able to carry firearms.
Under your definition, though, that it could push farther. In other words, Congress could change the statute and push out to the limit of anybody who wasn't a citizen. Isn't that where it would go?
Under our primary case, we think that's absolutely contemplated by the founding era evidence. But since 1968, the government has extended the discretionary ability to non-citizens, including lawful permanent residents and visa holders, to carry a gun. The question you should be asking is whether we must include something like 922 G5B or whether we may do it. And that's the only difference between our primary and our concessive case. For the foregoing reasons, we respectfully ask that this court reverse.
Thank you.
May I proceed, Your Honor?
You may.
Thank you. Madam Chief Justice, and may it please the court, my name is Vishali Chaudhary, and I rise on behalf of John Doe alongside my co-counsel, Sophia Quende. I will address why John Doe is covered by the Second Amendment, and my co-counsel will address why Section 922 G5 is unconstitutional as applied to him. The Second Amendment is not a citizens-only right. The Attorney General's citizens-only theory would permanently exclude all non-citizens from the people protected by the Bill of Rights and contravenes this court's decision in Verdugo-Urquidez. This court should reject that theory. John Doe is an individual who has sufficient connections with this nation and is a part of the people who retain a right to bear arms. This court should affirm the Ames Circuit for 3 reasons. First, this court already decided the definition of the people in Verdugo-Urquidez, and that definition controls the present inquiry. Second, under that definition, John Doe is a part of the people. And third, the Attorney General's alternative argument about legal status is also incorrect.
But the Verdugo case was not in the Second Amendment context, and counsel on the other side argues that in the Second Amendment context, we have a different frame for how we interpret that right, and that it focuses on the historical meaning of the terms at issue. What is your response to that?
Chief Justice Jackson, we think that understanding of the Second Amendment has already been foreclosed by this court's reasoning both in Heller and in McDonald. In both of those cases, this court found that the Second Amendment is not a second-class right, which is subject to an entirely different set of constitutional rules than other amendments. I think this also gets to a point made by my opposing counsel tonight, which is that this court could somehow consistently read the people to mean different things in different amendments.
But I think that in fairness, the Bruin's statement about it not being a second-class right, what counsel is saying on the other side is absolutely it has a more stringent test.
Your Honor, we don't think it has a more stringent test, and I think that's based on the plain text of the amendment itself. The Attorney General would have this court find that the framers, when writing the same 10 amendments, meant the people in different contexts that it was used, even though it repeated this phrase.
Have we ever found in another context, since you raise other rights, that an unlawful non-citizen has a constitutional right?
Your Honor, I don't think that question has been squarely presented before this court. However, there is indication in this court's jurisprudence, both in the First Amendment and Fourth Amendment contexts, that it has never understood those rights to be based on citizenship. Instead, in Verdugo-Urquidez, the only case in which this court has actually analyzed the term the people, it had an opportunity to define that as just citizens.
Isn't there that case Turner, that ancient case going way back when about excludable aliens and not having First Amendment rights?
That's true, Justice Saris. However, I'd like to distinguish that case on a few different grounds. First, that the Attorney General reads into the language in that case. However, that case is a case in which the individual had only been in the nation for 10 days and had explicitly argued for the overthrow of the government. And so in any case, he would not have had sufficient connections with the nation. And second, that 50 years after that case, this court held or commented in Bridges versus Wixson that, quote, freedom of the press and of speech is accorded to aliens residing within this nation. And I think that follows in the Fourth Amendment context as well in Verdugo-Urquidez.
But I know it's part of your sort of parade of horribles that that aliens would lose their First Amendment rights, but that's not clear to me. I mean, they might lose the rights of petition and assembly, right? But they wouldn't lose speech and religion because that's not attached at all to persons. It just says Congress shall make no law, right? So in petition and assembly, aren't those just political rights anyway?
Your Honor, we have a few different responses. First, that I don't think this court has treated those rights differently based on the use of the word the people. And second, that history does not show that any of those rights were, or any non-citizens were denied of those rights altogether. Instead, what history and the founding era generation believed was that these rights were not based on citizenship. And this gets me back to what this court laid down in Verdugo-Urquidez itself.
Are you saying that assembly and petition were not based on citizenship? Because I see. So that's where you're going. But what case do you have to support that? I mean, you've been talking about speech, but what about assembly and petition?
Your Honor, I don't think assembly and petition in particular have been a focus or a presented question in any of the cases before this court. However, I do believe there is historical evidence that even non-citizens petitioned the government. This gets me back to this court's own...
Well, they can petition all they want, but since they don't have a right to vote, I don't know how much good it's going to do them, right? So doesn't that support the other side's argument that there's a link between political community and these rights that are attached to the people?
No, Your Honor. I think the political community language from Heller, first of all, did not supersede or change this court's definition in Verdugo-Urquidez. And second, the Attorney General cites a multitude of different cases discussing that term, but none of those cases were cited by this court in Heller. Instead, right after this court used the phrase political community in Heller, it immediately cited Verdugo-Urquidez and recited the entire definition in full.
But you talk about what is cited in Heller. I mean, in Heller, Bruin, and Rahimi, the Supreme Court uses the word citizen, dozens of times. So I think you have a little bit of an uphill battle in persuading us that citizen is not what is meant when we're talking about the Second Amendment in particular.
Well, Chief Justice Jackson, although they use the word citizen, I think that was to describe the litigants in those cases, because in all of those cases, the litigants themselves were citizens. And what this court itself noted in Rahimi is that the language on law-abiding citizens or responsible citizens was used to describe those who uncontestably had this right, not to define the entire scope of the right. And again, in none of those cases was the question presented of whether or not the individual was a part of the people. Rather, the only case in which that question was presented was Verdugo-Urquidez, and that is the definition that controls the present inquiry.
Didn't Heller sort of cut back on that a little bit? In other words, the original Verdugo-Urquidez says political community or substantial connection, right? It's
yes, Your
Honor. Two-part. And Heller talks about political community. And if we stuck with the more recent, the Heller definition, wouldn't you read into that some sort of connection beyond being physically present in the country, even for a long time?
Your Honor, I don't think it changes the definition in terms of looking at sufficient connections. There, the court was not even clear on whether or not political community meant anything different from the definition, and I think it would still matter whether or not an individual is integrated in United States society. That gets back actually to the original meaning of the term the people. For example, we do use the colloquial definition of people from dictionaries at the time. However, that is indicative of what the framers understood that term to mean when they used it in the amendments themselves. And that definition was a nation, those who compose a community. It was not one that was based on citizenship. And so this community-based understanding is what was prevalent at the time. Additionally, there's also evidence that the principal drafter of the Bill of Rights himself, James Madison, did not think that these rights rested solely on citizenship. Rather, after the passage of the Alien and Seditions Acts, James Madison explicitly said that aliens should be afforded the advantages of the Bill of Rights as long as they remain within the country.
If they wanted it that broadly, wouldn't they have used the word persons? Now, if you're trying to figure out that every single word, the people, citizens, persons, they're all used in the Bill of Rights, if they wanted to go that broadly, wouldn't you use the word persons?
Well, Justice Saris, I think the court discussed this briefly in Verdugo when it noted that persons is considerably larger than the people, and it's used in the 6th and 5th Amendments when referring to trial rights. But the 1st, 2nd, and 4th Amendments we think are more based on an individual's membership in the community and the enjoyment of rights that they have as they live in that community. That's exactly the definition that this court came to in Verdugo-Urquidez.
But I think I worry a little bit about the administrability of the sufficient connections test, and that is what counsel on the other side points to as one of the reasons why we shouldn't say that that's the test to this scenario. What's your response to that?
Well, Your Honor, that gets me to my second point about why John Doe is a part of people and the application of this test. As you noted in the opposing counsel's argument, that is the nature of a standard. It affords discretion to courts in order to be flexible when determining constitutional rights. But at the same time, there are limits. For example, in Verdugo-Urquidez itself, when talking about undocumented immigrants in particular, this court noted that it could be sufficient in terms of their voluntary connection of the country and the acceptance of societal obligations.
But don't we necessarily need a bright line rule here? Because this is not just about courts making after the fact determinations, but it's about frontline people, like people doing background checks and selling weapons in firearms stores have to decide whether or not you're lawfully entitled to possess it. And so they can't be doing a multi-factor test. Do you belong to a church? How many years have you been here? Do you have citizen kit? Like, how are they supposed to make those decisions?
Well, of course, Justice Larson, and our position is that individuals like John Doe would seek declaratory relief that they are a part of the people and then be able to obtain arms. So those vendors wouldn't be having to make this decision. However, the courts
right, but whatever we say ultimately is going to affect the test that people in those frontline gun shops are going to have to apply.
Your Honor, I think it's evident that the courts applying this test frequently rely on the same set of factors, those being length of residence, employment, voting history, familial connections, and those are the exact same factors that the Ames Circuit itself relied on. And I want to get to the facts of this particular case. The only crime John Doe has ever committed was the nonviolent misdemeanor of illegally entering this country. But since then, he has demonstrated a commitment and to create an identity for himself in the United States. He has lived here for 12 years. He has since started a family, is a father to 2 American-born children, is an active member of civic activities within his community, and has even lawfully voted in the city of Ames for the past 8 years. He is an individual who is integrated with the community and is a part of the people as this court defined it in Verdugo-Urquidez.
What about the standard or the suggestion that he has to attempt to engage with the naturalization process in order to qualify?
Your Honor, I don't think that that standard is clear. For example, the Attorney General doesn't suggest what exactly would be sufficient under that standard. And moreover, the record itself does not suggest that he's never taken those actions. The record only reflects that he currently does not have status, but is entirely silent as to what actions he may have taken to obtain status. I think this also gets to why the—
But wouldn't it be on you? I know you're operating on a limited record, but ordinarily you're appellate counsel, but it would have been trial counsel's job to establish a record, correct? So any deficiencies in the record would be a problem for your side.
I think so, Your Honor, but I think even though this court doesn't know whether or not he has affirmatively taken those actions, that isn't the point. And the reason why is because legal status is not a standard that this court has relied on before, and it's also not a plausible or practical one. For example, under the Attorney General's standard, an individual could have legal status, be lawfully within this country for multiple years, and create substantial connections. But the day the executive revokes that status, or they, for example, overstay a visa, the Attorney General would have them excluded from the people protected by the Bill of Rights, notwithstanding all of those connections that they made while they were legally in the nation.
Can I ask you a hypothetical? Can the government require somebody to register to own a gun?
Yes, Your Honor, I think the government could.
So you have someone who's illegally here. You're requiring him to register. You're essentially outing him in terms of his status. As a practical matter, doesn't it undermine the ability to track weapons in this country that I think almost every court has said is lawful? How would this work?
Well, Your Honor, to be clear, there's currently not a federal firearm registry. Second, John Doe himself is only seeking declaratory relief that the law would be unconstitutional as applied to him. And so through that avenue, he would be able to have a firearm for self-defense in his home.
Without registering it?
Your Honor, there currently is no federal firearm.
Say it's a state registry. Like Massachusetts, we've got one of the toughest ones. Right?
Yes, Your Honor.
You should all know. We have a pretty tough one. See, you're required to register when you buy a gun and they check it out and you have to fill in paperwork. That is federal. And it's, how would you even begin to enforce something like that?
Your Honor, I think states have a multitude of areas that they could look to in terms of regulation. I think my co-counsel would further explain as to how far they could burden an individual's right in terms of registration or other means. But as to the question of whether or not he's a part of the people, I don't think that the state's potential difficulty in regulating this could exclude him from exercising a fundamental and protected right.
No, go ahead.
Can you speak quickly to the distinction that counsel on the other side tries to make, I guess, as a fallback position, drawing the line between unlawful non-citizens and lawful non-citizens, and saying one could be considered part of the people and the other not?
Of course, Chief Justice Jackson, we do think that lawful status in certain cases is indicative of the connections you've made with the country. For example, certainly all green card holders or those who have permanent legal residency have shown sufficient connections by being in the country for a length of time, submitting to its laws, and being actively involved in the community. But that just gets back to the basic test, the threshold question of whether or not an individual has sufficient connections with this nation. The Attorney General would have courts not follow the facts of a case and rather simply look to status. But the basic threshold question in both is how connected an individual is with the nation. It would be proper for this court to grant discretion to courts the same way it has under Verdugo or Quides, because these are complex questions that involve the unique complexities of individuals' lives.
Let me ask you another question, I think, about the people, and I didn't see it in the briefing on either side, but no one talks about the first mention of the people in the Constitution, and that is in the preamble. So the preamble says, "We, the people, in order to form a more perfect union, establish justice, etc." Does that have any bearing? Because it seems to me that that might support the argument on the other side, and I'd like to give you a chance to respond to that.
Of course, Justice Larson, I think that actually detracts from the Attorney General's argument because it still implies this community-based understanding of the people, a sense of oneness, a sense of a common shared identity. And John Doe is an individual who has created an identity within the United States. He's been.
But doesn't it go to the people who formed the union? And doesn't that mean that there had to be political rights in order to form the union?
Your Honor, I don't necessarily think that that would be the correct understanding, but even if this court were to adopt that understanding, I still think it would have no bearing on the way that the drafters use the people when referencing natural rights in the Bill of Rights. The Attorney General, for example, distinguishes the fact that the founders used citizens in other parts of the Constitution, but we also think that that is itself indicative that they understood these terms to refer to different groups of people, and that the fact that the Second Amendment, First Amendment, Fourth Amendment use the people, it necessarily implies a broader meaning than just citizens. Because the Attorney General's argument is not supported by the text, historical understanding, or the precedent of Verdugo-Urquidez laid down by this court itself, this court should reject it. John Doe is a part of the people who has sufficient connections with this nation, and we ask this court for those reasons to affirm the decision of the Ames Circuit.
Thank you.
Thank you.
Madam Chief Justice, and may it please the court. I am Sophia Quende, representing John Doe. At its heart, this case is about a father seeking to keep a handgun in his house to protect his children due to a rise in home breakings. Yet Section 922G5A prevents him from doing so solely based on his immigration status. This law is unconstitutional as applied to Mr. Doe. In Bruin, this court was clear that the scope of the Second Amendment should be preserved as it existed at the founding. The Attorney General's overgeneralization of historical principles will permit legislatures to disarm anyone they choose, effectively nullifying the Second Amendment. The Second Amendment is not a second-class right. It demands more than the Attorney General provides today. As a threshold matter, the burden is on the Attorney General to demonstrate the constitutionality of Section 922G5A. In Bruin and Rahimi, this court was clear. When the government regulates arms-bearing conduct, it bears the burden to demonstrate the constitutionality of its regulation.
But counsel on the other side mentioned that there is a presumption of constitutionality or lawfulness with respect to certain kinds of regulations, and that this one falls into that category. What is your response to that?
Your Honor, we disagree. The Attorney General's position is that dicta from Heller, decided more than a decade prior to the articulation of the Bruin standard, somehow carved out an exception to Bruin. Your Honor, this is not a plausible reading of the standard. There is no long-standing exception, as the Attorney General claims. Bruin itself involved a 102-year-old New York law, and in that case, the court was clear that the government bore the burden of demonstrating the constitutionality of the law. 922G is only 56 years old. It is not as long-standing as the law in Bruin that this court clearly noted that the burden was on the Attorney General to demonstrate its constitutionality. Your Honor, it is unclear how a burden shifting in a historical analysis test like Bruin would work in the first place. Petitioners would simply, or challengers of the law would simply say there is no law supporting this law, and it would still be on the government or whoever is trying to regulate to demonstrate that there exists a law. So as a practical matter, it will have no...
So your point is that as a practical matter, Bruin departed from Heller's language. I mean, the standards that she's talking about, or the presumption is in Heller, that there are a certain category of these kinds of prohibitions that are presumptively okay. And you're just saying that that no longer is the case post-Bruin.
Yes, Your Honor. Our position is that that is not the case, except for the provisions that were specifically mentioned in Bruin. That might be the case for those, but we don't take a strong position one way or the other. It's possible that it might not be. Your Honor, the reason why here the government has failed to meet its burden, and the reason why it's because it has overgeneralized the principle so much that it would water down the Second Amendment right.
Well, let's talk about that, because you mentioned in your opening statement that the government can disarm anyone they choose. I didn't hear that as the Attorney General's argument. They suggested that they can disarm people who are lawbreakers, and that's not anyone.
Your Honor, the Attorney General's principle is that anybody who commits any crime whatsoever may be permanently disarmed. there are tens of thousands of civil and criminal laws. So by breaking any civil law, anyone can be disarmed. Speeding on the sidewalk is a crime in some states.
They aren't talking about civil infractions. They're only talking about criminal violations.
Your Honor, but they didn't limit their position to criminal violations. They said all laws. Civil laws are part of these laws that seem to be included in the Attorney General's.
Suppose if we were to draw a line, why would it be wrong to say that everybody who violated a law, i.e. illegally being here, can't have a weapon?
Your Honor, because that is inconsistent with our nation's regulatory tradition. Brewing requires us to examine the why of historical laws and the why of modern-day regulations and make sure that there are a close fit. All of the laws cited by the Attorney General involve a direct threat of violence. The offenses themselves involve a threat of violence. If we look to the 1692 Massachusetts statute cited by the Attorney General, this court, examining that same statute in Brewing, noted that it codified the common law offense of going armed to terrorize the people. The Attorney General claims that there is some sort of non-violent peace breaking, but as then Judge Barrett noted in her dissent in Cantor v. Barr, peace breaking involved an element of violence. It wasn't meant to target non-violent offenders. Failing to provide any such laws, the Attorney General relies on state ratifying conventions that were rejected. They didn't even make their way into the Constitution. The Massachusetts Convention, which the Attorney General cited, referred to peaceable citizens, but peaceable itself did not mean non-law breaking. It meant free from tumult, free from revolt, free, non-bloody, non-violent. There is no indication that peaceable meant non-law breaking. If we look even to the Pennsylvania proposal, the Attorney General claims that because Heller said it was highly influential, it matters more to the understanding of this right. But Heller said the Pennsylvania proposal was influential for the language of the proposal that actually made its way into the Second Amendment, which was the people. And Heller said that in the context of whether the Second Amendment was a collective or individual right. The crimes committed that is referenced in the Pennsylvania proposal had only been interpreted in that proposal to include crimes like insurrection, which included an actual threat of violence. As then Judge Barrett in Cantor v. Barr noted, nobody else has ever interpreted crimes committed to mean every crime that could possibly be committed.
But why not this crime? I mean, this crime is continuing. It's not a one-time thing. As long as he remains in the country unlawfully, he has broken the law and continues to do so.
Your Honor, because law breaking isn't the principle to draw from this analogy. The question is, why was the law breaking? And if we look to the laws that the Attorney General provides, the 1692 Massachusetts statute, the 1795 Massachusetts statute, all of these are free laws, involve offenses themselves that include violence. Illegal entry into the country does not include violence.
So go ahead. All right. I was just going to say, as a practical matter, I keep coming back to this. So you have all these people who are unlawfully here. They're not going to be able to license or seek licensing for their guns because that essentially shows that they're here and might expose them to being removed from the country, right? So now you have a very big risk of violence when law enforcement goes in to try and remove them because they're going into households that they don't know whether the person has a firearm or not. And doesn't the Congress have a right to be worried about that?
Your Honor, Congress does have a right to be worried about that, but the Congress can only enact regulations that are consistent with our regulatory tradition. But Your Honor, to that point, there is no federal firearm registry, and in fact, Congress has a law that bans the federal government from using NCIS background information to create a federal firearm registry.
Don't people have to get licenses in most jurisdictions?
In most, but Your Honor, we have 9 states that ban the creation of state registry. Ames might be one of those states.
I mean, I'm just saying some states do, some don't, right?
Yes, Your Honor, that's fair. Ames might be one of the states that says you don't need
You have to get a license.
Yes, Your Honor, you do. But even if you do, like the government has done with the IRS, which provides a pathway for undocumented immigrants to pay taxes without the risk of deportation, the government could very well provide that same pathway for undocumented immigrants to own weapons without being subject to deportation.
So what about the other historical tradition to which they refer?
Your Honor, the other historical tradition to which the government refers to is too broadly drawn. The government says Congress can disarm anyone that it deems disloyal or to lack undivided allegiance. But, Your Honor, the tradition is way narrower than that. If we look to all of the disarmament, the Loyalist disarmaments, the Catholic disarmaments, the Confederate disarmaments, all of this happened in the time of internal wars in the United States. We want to start with the Southerners, Your Honor, because the Attorney General makes a broad and erroneous claim that all Southerners were disarmed during the Civil War. This didn't happen. To support this broad proposition, the Attorney General cites two general orders from when the South was under military rule. The first order disarmed only those who had borne arms against the United States, the Confederates. The second order prevented Southerners from concealed carry, but allowed them to open carry, so it's altogether irrelevant to this inquiry. But to see the centrality of the war to the disarmament, Congress, following the re-entry of the South into the Union, refused to disarm the Confederates. In fact, the 40th Congress disbanded the Southern militias, but denied a proposal to disarm all of the individuals who had taken part in these militias for fear of infringing on their...
But weren't the ones who were disarmed only allowed to re-carry their weapons after they swore an oath?
Yes, Your Honor, there was a provision providing that they could get their weapons after they swore an oath, but some of them didn't do this, and still once the South had re-entered into the Union, Congress said no oath necessary. We do not disarm people based on allegiance anymore, because it was the war itself, it was that internal strife that made this okay. If we look to the Loyalists presented an existential threat to the nation. To quote John Adams, Loyalists were guilty of the very invasion of Boston, aiding, abetting, comforting, and assisting the British Army. In fact, some 50,000 Loyalists joined the British Army. The Continental Congress's recommendation to the states was a direct result of the fear that the Loyalists were going to join the British and help in the overthrow of New York, as they had done in Boston.
I'd just like to go back to Justice Jackson's question. So the concern that you're raising is that that all criminality, that's too broad. But she asked you, why not this particular law? And I think the hard part of your case is that you're trying to assert membership in a national community by breaking the law, the very law that says you can't enter the nation. And that's just a tough sell. And so why isn't the answer this law in particular, even if it can't be all criminal laws, why isn't this the place where Congress is free to draw the line?
Your Honor, because consistent with this court standard in Bruin and Rahimi, the question would be, what is special about this kind of law breaking? And to do that, we'll need to look at what was special about the law breaking that allowed the earlier generations to disarm people. If we look at AFRE law cited by the Attorney General, this all involved threats of violence. But when we look at Section 922, illegal entry, there is no direct threat of violence. You need to pile inference upon inference to get to the violence. The first inference being, we might deport this person. And then the next inference being, when we go to deport this person, they might resist. This is too much of an attenuated connection as opposed to the direct threat of violence involved in going armed laws.
What about the colonial era evidence that there were laws prohibiting Catholics from arming themselves? There were some categorical prohibitions.
Your Honor, we have 2 points to make on this issue. The first being that Catholic disarmaments occurred under the English Bill of Rights. The English Bill of Rights extended the right to bear arms to Protestants. The right was not extended to Catholics in the first place. Secondly, the disarmament of Catholics happened in the context of the French and Indian War, and it was because of the worry that the Catholics would join Catholic French in a war that was seen by many as a war between Catholic France and Protestant Britain. It fits squarely within the tradition that we have presented, that it was the active fear of overthrow of the government by an internal political enemy.
But we still come back to the point that even Catholics could sometimes get their arms back if they would convert, if they would swear an oath of loyalty. We see the loyalty oath coming up with respect to the loyalists as well. And your client has an allegiance to a foreign sovereign. So why isn't that just a presumption that Congress can draw? That if your formal allegiance is to a foreign state, you can be disarmed because we can make that presumption.
Your Honor, first, our client still has allegiance to the United States, as understood by the founders. If we look to
Blackstone... But he has an opportunity to go through the naturalization process and demonstrate that, if that is available to him, or might be available to him.
Your Honor, the likelihood is very low, but assuming that it's available to him, that is a separate inquiry. Bruin requires that the historical laws and the modern laws comparably burden the right to armed self-defense. A loyalty oath is merely an oath. The naturalization process is substantially more burdensome than a simple oath. If today Congress were to pass an amendment to 922G5A saying that if undocumented immigrants could go to the courthouse like loyalists could do and take a loyalty oath swearing their allegiance to the United States, then perhaps it would alleviate some of the burden that we have about the widespread nature of this law. But based on the principle the Attorney General identifies, this law will propagate the very abuses that were rejected by the Second Amendment. The argument is so broad that the government can basically decide that a specific group lacks allegiance and then set up a set of formal procedures for this group to prove their loyalty to the government. With this principle, Congress can disarm anybody it wants, or at least governments can choose to disarm political dissidents. This is precisely what happened with the English game laws. The English game laws that this court noted in Bruin and in Heller had so thoroughly disgraced the English right and were rejected by the Second Amendment. Here, the Attorney General proposes two broad principles. Between these two broad principles, nobody is going to have a Second Amendment right. The legislatures are just going to disarm anybody. If the principles were so broad, there would have been no point to enumerate the Second Amendment in the first place. The point of enumeration is that it takes the right out of the hands of legislatures. If it were the case that you could commit any crime whatsoever, like opening up a bottle of ketchup in the store and get disarmed, legislatures would never... The founding era would never have bothered to enumerate the right anyway.
You don't think this is different because Mr. Doe is continuing to break the law today?
No, Your Honor, we do not think it's different because of that. We still think that even if this court were to think that this is a special kind of law breaking, the burden imposed by this law is a permanent disarmament. It isn't a comparable burden to anything that has been provided by the Attorney General. Because the Attorney General's principles are so broad as to disarm a large swath of the population and effectively nullify the Second Amendment, we ask that this court reject such broad principles. For these reasons, we ask this court to affirm the Ames Circuit and find that Mr. Doe is part of the people and Section 922G5A is unconstitutional as applied to him.
Thank you. Whenever you're ready.
May it please the court. I want to spend these 3 minutes making one point about both issues, which is that Doe provides no pathway to a holding that is rooted in historical evidence, and any test that is devoid of history is unworkable, unadministrable, and not contemplated by this court in both Bruin and Rahimi. On the first issue, Doe provides you with two theories that are directly contradictory. First, he tells you that the founding era evidence which he provides on pages 16 to 24 of his brief is all geared to show that the right to bear arms was possessed by every individual in the United States. He provides you with dictionary definitions that show that the right was held by every person in a town, and he repeatedly analogizes to the Fifth and Sixth Amendments, saying that the word the people is synonymous with person, any person within the jurisdiction, and the accused. But then, even he doesn't defend this test. He then tells you that the primary line that he's drawing is Verdugo or Quides, which definitionally says that not all people within the United States have sufficient connections and therefore have Second Amendment rights. These two tests are directly contradictory. Verdugo's line is an unworkable and unadministrable one that's free from history. Doe provides you with only 3 cases as Sigard posts for it. A case by Judge Reeves in the Southern District of Mississippi that was subsequently abrogated by Medina Cantu this August. A case by Judge Wood called Meza Rodriguez that concerned an individual with 2 times the connections that Mr. Doe has. And Martinez Aguero from Judge Smith in the Fifth Circuit, which concerned an individual with lawful status. At the end of the day, Mr. Doe can't tell you the single most important thing, which is that he has sufficient connections under his own test. And because we don't have a test, we simply can't say for sure. At base, this inquiry is subjective. Because it is subjective, it is inconsistent. Because it is inconsistent, it is unfair. And because it is unfair, it is highly likely to conflict with Congress's policy judgments with respect to 40 million individuals living in this country who are non-citizens. On the second issue, we want to make 2 points. The first is that we cite numerous laws disarming individuals who are nonviolent. Peacebreaking is at its core a nonviolent offense, and states subdivided this offense very early. So by the early 1800s, that Massachusetts law about peacebreakers was a law disarming individuals who were drunk and disorderly in public. Second, we cite numerous fraud statutes that disarmed individuals who were nonviolent and committed things that look today like white-collar offenses. Second, the Loyalist laws that were referenced by my friend is one of the places where you can be sure that Doe's principle about active wartime is under-inclusive of the founding era evidence. Though some Loyalists did give material aid to the Redcoats, the vast majority of them were nonviolent. They were butchers and bakers and candlestick makers. They went to church. They played on their founding era softball teams. They looked just like Doe, except they hadn't sworn allegiance by the law provided by Congress in all of those statutes. We think that's the single strongest analogy to Mr. Doe today, and the principle provided by opposing counsel is under-inclusive. For the foregoing reasons, we respectfully ask that this court reverse.
Thank you. The case is submitted.
All rise. All rise. You may be seated.
Well, this was an incredibly difficult decision. Each of us is going to take one of the categories to announce the winners. But first, let me just congratulate both teams. You did an excellent job and made it very tough for us to make this determination. Start with Judge Larson.
Okay. Well, I just want to echo what Justice Jackson said. This was just a tremendous round of oral arguments. I for many years, since, I don't know, the 2000, sometime around there, have been the moot court advisor at Michigan Law School. And every year the judges come up and they say, oh, if only we had advocates who are this good in my court. And I thought, they're just saying that. And now I've spent almost 10 years on the other side of the bench, and I can tell you that at least with respect to this particular group, you are more than welcome in the Sixth Circuit at any time. The arguments were just tremendous and of just super high caliber. Unfortunately, we have to pick one of you as the winner, and that put us in a very difficult position. We were deliberating for a long time. Happily, nothing came to violence, so we can't be disarmed. But I guess I'll just get right to it and say that we collectively agreed that Emily Malpass wins Best Oralist.
So I will announce the winner of Best Briefs, and let me say that both of the teams wrote briefs that were effective, were thoughtful, incisive. You used source material in a very interesting and important way, especially all of the historical evidence, which is sometimes tough to be able to deal with. And so both of you really had a wonderful set of arguments and presentations. Today we will award unanimously Best Brief to the respondents.
So overall, that's what I'm supposed to give the best team overall. And let me tell you how proud I am to have listened to this advocacy from, I mean, just spectacular. It makes me proud of Harvard Law School, makes me proud of all of the work that you all put into it. You're the best of the best, and this was unbelievably difficult to do because each one of you excelled orally and in brief writing, and so it was a tough task for us to come to. Overall, we found that the best team was the respondent. Yeah, whoa, standing O. Standing O. It just is a multifactorial test that we talked about, and in some ways we talked about the fact that the brief for the respondent was much harder because it was counterintuitive. That what was being asked was a deep dive into the history and challenged. Relied on the correct case right from the get-go, the one that best favored their side, and also rebutted some of the notions of citizenship. So we thought that was a tough task, and plus on the oralist, you were all phenomenal. Really, I would have passed out. I just would have been gone. You know, it's just each one of you came to it with a strength on particular points, and we thought overall the respondents had it, but it's, as they say, by a feather. So congratulations to you and to everybody here.
We are adjourned.
All rise.